Legal and Privacy Brief for February 09, 2026. Congress is weighing bipartisan proposals to repeal or sunset 47 U.S.C. Section 230, the 1996 law immunizing online platforms and users from civil liability for third-party content, with no proposed replacement standard attached to any bill. A California Superior Court dismissed SEPA Section 631A, wiretapping claims against retailer Beyond Yoga, finding that end-to-end encrypted chat messages cannot satisfy the in-transit interception element required by the statute. Denmark's Datatilsynet issued serious criticism against 51 municipalities in a coordinated Chromebook data protection case, 2025-431-0053, signaling active DPA enforcement on EdTech cloud deployments. Here's the full breakdown of today's top legal and privacy stories. Next section, policy changes. Section 230 turns 30. Bipartisan repeal and sunset proposals in Congress. Congressional proposals from both parties would repeal or sunset 47 U.S.C. Section 230, which immunizes online intermediaries from civil liability for content posted by users. The proposals have been framed as a response to the harmful and anti-competitive behavior of large tech platforms, but no bill has specified what legal standard would replace the current immunity. EFF argues the three most discussed alternatives: strict liability, a negligence-based duty of care, and a notice and takedown system, each produce worse speech outcomes than Section 230. Strict liability would force intermediaries to pre-screen all user content before publication. A negligence standard would create open-ended litigation risk that incentivizes over-removal of lawful speech rather than defense of it. Notice and takedown, as modeled by the DMCA's Section 512, is routinely abused by parties seeking to suppress legitimate content without legal review. EFF further argues that any of these alternatives would consolidate market power among large platforms that can absorb litigation costs, rather than constraining them. Compliance action. Organizations that operate user-facing platforms, comment sections, review systems, or community forums should assign legal or compliance staff to track Section 230 legislation through the current Congress. A repeal or modification would require new content moderation policies, updated terms of service, and potentially formal legal review pipelines for user-generated content before publication. Document current moderation practices and your reliance on Section 230 as a litigation defense to establish a baseline. Sources: EFF Deeplink's 30th birthday, EFF Op-Ed Daily Journal. Wikimedia Foundation sees takedown requests double in a decade. Expands legal team. Wikimedia Foundation received 664 content removal requests in 2024 alone, compared to 304 over an entire two-year period a decade earlier. Of the 664 requests, only 4 were granted. Wikimedia's Associate General Counsel stated that the volunteer editor model for Wikipedia would not be viable without Section 230 protection, because the volume and variety of potentially defamatory content in biographical and current events articles would generate enough litigation risk to bankrupt the organization. Wikimedia has expanded its legal team to defend editors against claims, including cases involving biographies of living persons and politically sensitive historical content. Yelp similarly uses Section 230 to defend its automated review ranking systems and to resist legal pressure from businesses seeking to suppress negative consumer reviews. Compliance action. Operators of any platform where users post content about identifiable individuals or businesses should review their Section 230 reliance and ensure their terms of service. DMCA agent registration, 17 U.S.C. Section 512, C.2, and content moderation documentation are current. If Section 230 is weakened, this documentation will be essential for negligence defenses. Sources: EFF Wikipedia, EFF Yelp. Next section, Litigation Updates. Beyond Yoga website chat feature SEPA section 631. A. Dismissed on summary judgment. Los Angeles County Superior Court in a putative class action filed in Los Angeles County Superior Court. Judge Carolyn B. Cool granted summary judgment to defendant I Am Beyond D/B/ a Beyond Yoga, dismissing claims that the retailer aided and abetted violations of California Invasion of Privacy Act, SEPA, Section 631A. The plaintiff alleged that a third-party chat widget on the Beyond Yoga website intercepted her communications without consent. To sustain a SEPA Section 631A claim, a plaintiff must show that a third party read or attempted to read the content of a communication while it was in transit. The court held that because the defendant's expert demonstrated all chat messages were encrypted when sent, while in transit, and when received, no in-transit interception could have occurred. The plaintiff's rebuttal expert declaration was inadmissible because it was not signed under penalty of perjury, and the admissible portions of that declaration only addressed how the vendor operated on its own website, not the defendant's website. Because the plaintiff could not establish the underlying Section 631 violation by the third-party vendor, the aiding and abetting theory against Beyond Yoga also failed. The court also identified AI-generated hallucinations in the plaintiff's briefing, including case citations where the quoted language did not appear in the cited opinions. The court declined to impose sanctions, but stated that if the summary judgment decision is reversed on appeal, it would consider whether the AI-generated errors rendered plaintiff's counsel inadequate to represent the class. Compliance action. Companies operating website chat, session recording, or behavioral analytics tools in California face ongoing SEPA Section 631A class action exposure. The key defense here was end-to-end encryption in transit, documented by the vendor in a form admissible as expert evidence. Obtain written representations from all chat and session replay vendors, confirming their encryption standards for data in transit. If a vendor cannot confirm end-to-end encryption, assess exposure under SEPA Section 631 and Section 638. 51. Pen register, and consider switching vendors or adding a consent banner with an opt-in for chat monitoring. For legal teams using AI for research or drafting, implement mandatory human verification of all case citations before any filing or regulatory submission. Source: Inside Class Actions. Next section, Privacy Developments. Datatilsynet issues serious criticism against 51 Danish municipalities' Chromebook GDPR case, 2025-431-0053. Denmark's Data Protection Authority, Datatilsynet, issued serious criticism against 51 municipalities in case 2025-431-0053 related to the use of Chromebooks and Google services in schools. The decision involves failures in GDPR compliance for student data processed through Google's cloud infrastructure. The scale of the action, 51 municipalities cited simultaneously, indicates a coordinated enforcement sweep by Datatilsynet rather than a complaint-driven investigation of individual actors. Full case details are in Danish. An English summary has not been published as of the brief date. Compliance action. EU and EEA organizations deploying Google Workspace for Education, Chromebooks, or equivalent ed tech platforms should review their data processing agreement with Google and assess whether student data transfers to Google servers comply with GDPR Chapter V transfer requirements and Article 28 processor obligations. Organizations in non-EU jurisdictions deploying these tools for minors should also check applicable state student privacy laws, e.g., COPPA, FERPA, State Student Data Privacy Acts. Source: GDP Rub 2025-431-0053. Flock Alper contracts face organized municipal resistance over civil liberties concerns Flock Safety's automated license plate reader. Alper contracts have expanded to municipalities across the U.S. but jurisdictions including Austin, TX, and Cambridge, MA, have declined or terminated contracts following public campaigns. EFF's documentation indicates flock Alper data has been used to track individuals seeking abortions, protesters exercising First Amendment rights, and communities subject to discriminatory policing patterns. The legal concern centers on the absence of statutory frameworks governing data retention, permissible use restrictions, and interagency data sharing for Alper-collected information. EFF is hosting a public webinar on February 19, 2026, 12:00-1:00 p.m. Pacific, covering the legal implications of Alper deployments. Compliance action. Law enforcement agencies, municipalities, and security contractors using Alper systems should verify that written data retention and permissible use policies exist for all license plate data collected. Absent formal policy, Alper data use creates exposure under the Fourth Amendment, Carpenter v. United States, 138 CT, 2206, state wiretapping and surveillance statutes, and emerging state biometric/surveillance ordinances. If your jurisdiction has an Alper vendor contract, confirm it includes a data use limitation clause binding on the vendor and all downstream data recipients. Source: EFF Deep Links. Next section, Compliance Takeaways. Website chat and session recording tools, California. Verify all third-party vendors that process communications on your website use end-to-end encryption for data in transit, and obtain written vendor documentation confirming this. If encryption is absent or unconfirmed, assess SEPA Section 631A, class action exposure, and consider adding a conspicuous consent mechanism before the chat session begins. Section 230, Contingency Planning. Assign compliance or legal staff to track Section 230 legislation in the current Congress. If any bill advances to markup, initiate a gap analysis comparing your current moderation practices to what a negligence or notice and takedown standard would require. Document existing Section 230 reliance as a litigation defense baseline now. Ed Tech and Student Data, EU/EA. Audit Google Workspace for Education or Microsoft 365 Education DPAs against current GDPR Chapter V transfer requirements. The Denmark decision affecting 51 municipalities simultaneously indicates Datatilsynet is conducting proactive sector-wide enforcement, not responding to individual complaints. Remediate before receiving a formal inquiry. Alper and surveillance tool governance. Any organization operating or accessing Alper data should have a written policy covering retention periods, typically 30-90 days unless under active investigation, permissible use categories, interagency sharing restrictions, and audit logging of data access. Absence of written policy is the primary vulnerability in Alper-related litigation. AI-assisted legal and compliance drafting. The Beyond Yoga Court identified AI-generated hallucinated citations in plaintiff's briefing and placed future sanctions on the table. Compliance teams and outside counsel using generative AI for document drafting must implement a mandatory citation verification step before any document is submitted to a court, regulator, or counterparty. The risk is not theoretical. Sanctions proceedings are now on the table in this case if appealed. That concludes today's legal and privacy brief. From Carolina, Clear Tech, for informational purposes only, not legal advice.